The structure you choose for your company will either make or ruin your business ideas. Relax. This is day two of the 30 days Know Your Kama challenge. And I am your super Kama lecturer, Chidioki Ochogo. Let's go. Today we're looking at sections 18 to 54. We're looking at the incorporation of companies, various aspects, various types of companies as contained in our Kama. All right, so section 18 first starts with any two or more persons may form or incorporate a company by complying with the requirements of CAMA. However, remember yesterday on day one, I told you one of the things that you should know when you are studying CAMA is that when you see a general rule, there's most likely always going to be an exception. So if CAMA tells you that you can do something like this, don't stop there. Try to see if there are other provisions that will tell you, oh, except you do it this way, except you do it that way. Because in this case, sections 18 sub 2 goes further to say that even though two or more persons can form a company, one person can actually form and incorporate a company. And I told you also yesterday on day one that when Kama says you can do something, they go ahead to tell you capacity of people who can actually do these things or people who cannot do this. And for incorporation of company, even though we said that two or more persons can form a company, or in the case of a private company, one person can actually form a company, it goes, section 20 tells us people who cannot join in the formation of a company, and they are people who are less than 18 years old, people who have an unsound mind, an undischarged bankrupt, or a person or people who are disqualified under sections 281 and 283 of CAMA from being a director of a company. When we get to 281 and 283, we would see, but for now this is where we are. However, it goes ahead to say that these persons are disqualified under this subsection 120 subsection 1 that we just read now. If there are two other persons who qualify, right, to form a company, if they actually form a company, then these people may not be, would I say, restricted. They can actually then join to form a company because now we now have two people who actually are qualified. So, for example, I'll go ahead to say, very perfect example. You want to incorporate a company and you want to give your less than 18-year-old child shares, that's making them members in the company, and you're worried because of this restriction, because of these qualifications of disqualification I just read. Don't worry, once you have two people who actually qualify, your less than 18-year-old can actually join in the formation of a company. We go ahead to see the types of companies in sections 21. Company limited by shares, company limited by guarantee, an unlimited company. When I was reading, I was like, okay, when I was, getting ready for the shoot, I asked myself, have you ever registered or even been close to somebody who was registering an unlimited company? And my answer is no. I haven't. I haven't because it's very rare. A company of any of these types may either be a private company or a public company. So, a private company in the sense that Scammer just says that your memorandum of association says that you're a private company, and of course, your members shall not exceed 50. So, once your members exceed 50, you're right on your way out of a private company. And it also goes ahead to state, very important to note in section 22 sub 4, that where two or more persons jointly hold shares, they shall be counted as one. So if two or more persons jointly hold shares, you can't count them individually. You count their shares as one. So you count their membership as one, right? We go on to say a public company is is the opposite of a private company. So if a company is not a private company, it is a public company, sections 24. Sections 25, an unlimited company shall be a company registered with a share capital not below the minimum issue capital under sections 27 sub 2 of this act. And I'll just add that an unlimited company is one that the liability of the members are not limited. Company limited by guarantee. I think it's very important. Remember, we said that the structure that you choose for your company would either make or ruin your business idea. It's very important most times when people want to incorporate a company, maybe towards a goal, towards research, towards charity, towards education, and they're not even sure how they want to go about it. It's very important for you to speak to your lawyer or whoever it is that you're speaking with in respect of incorporating your company, because for a limited there's a thin line between company limited by guarantee and incorporated trustees. A lot of people mix that up, real like it's very common most times for people to mix that up. But I'm going to let you know that for sections 26, for a company that is limited by guarantee, they can actually have income and properties, but it must not. Anyone who incorporates a company by guarantee just knows that you're not creating a company that would generate profits that should be shared amongst its members. So that's one of the key things of a company limited by guarantee. The income and the income and profits cannot be shared amongst its members. And would also like to state that, of course, the registration of a company limited by guarantee is actually um, done with the authority, the approval of the Attorney General. I'd just like to add that if anyone actually creates a incorporates a company limited by guarantee and the profits are actually shared amongst its members, it is an offense. Sections Sections 26 sub 11 says that it is an offense. And you know what an offense is. There'll be penalties applied to that. We then go on to the memorandum of association. The memorandum of association basically there are some section 27 outlines the requirements that are supposed to be contained in the memorandum of association. And of course, top on the list is the name of the company. Of course, can you have a memorandum without the name of the company on it? We then go ahead to see the registered address. That's you have to state that the company is situated in Nigeria. You have to state the nature of the business, the objects of the business. You have to state the shares if there are any shares, and also state the people, the shareholders. What else? You have to state if it's a private company or a public company. We go down to section 30, which addresses change of name of a company. So if by mistake, because it's usually a mistake, the corporate affairs commission actually registers a company that is similar to an already registered company, they can actually let you know to change your name and give you time to actually change your name. I think it's 6 weeks. Yes, sections 30, yes, sub 1 says 6 weeks. And I would also love to add that the change of name does not inadvertently affect it does not create a defect to anything that you have done in the past, or even if there's a legal proceeding, it doesn't change anything. It's still the same company, it's just that there's a change of name. We go on to reservation of name. So before you incorporate a company, you should actually apply for the reservation of the name on the CAC portal. Reservation of name actually lasts for 60 days. If you've not incorporated the company within 60 days, you lose the right to that reservation. We go ahead to the articles of association. The CAC actually has a model article of association, so you can either adopt all of it or some of it, or include whatever it is that that suits your organization, because the article of association is almost like it is not almost like it is actually the document that prescribes the regulation for your company. Upon incorporation of your company, the CAC actually registers your documents, and once it does, it's recognize that you have been registered. So the effect of the registration is that your company shall then be a body corporate that can sue and sue in its own name, right? Own its properties, hold its properties, dispose of it as the directors and the members agree, and depends on the article of association. So ultravirus, effects of ultravirus is the next, and ultravirus is just doing something that is out of your power, your established power, what you've already agreed that the company can do. If you do something outside that, that's ultravirus, and it is prohibited for a company to actually exceed its powers that has been conferred upon it by its memorandum and article of association, right? Or conferred on it by CAMA. So one of the effects of ultravirus, if people ask, "Oh, I've gone ahead to engage with this company or gone ahead to, complete a contract," doesn't necessarily affect you. However, if the contract is yet to be concluded or the action is still ongoing, the members can actually get an injunction to stop the performance of that contract. We then go on to sections 47. So notice that we are skipping. We're just reading out the ones that we feel we should read out. You are on this journey with me. Remember, I'm not the only one reading Kama. So it's a call for you to also, pick up your Kama. Section 47 says that every member actually has the right to a copy of the memorandum and article of association. And then it goes for that to say, of course, I think section, I'm not sure now, the particular section that says that if there's an alteration, the copy to be used is the one that has been altered, right? Yes, 48 says 48 addresses that. So where there's an alteration, the copy to be used is the one after the alteration, not the one before the alteration. And of course, the alteration of a memorandum of association is to be done by special resolution in accordance with the provisions of CAMA. There are days that have been stipulated for you to notify the CC of any such alterations. I think that's where we're going to call it a day for day 2 of the 30 days Know Your CAMA challenge, and I'll see you on day 3.